Mr. Block and myself do not want to represent Mr. Gideon if he doesn't want us to.
I'll speak for my own self. I'll make my own pleas. I don't want to make any pleas for me.
You don't want Mr. Block and Mr. Simon to represent you?
I do not want them.
Mr. Block, Mr. Simon, you're excused. Thank you.
Thank you, Your Honor.
Now, Mr. Gideon, under no circumstances do I want you to try your own case again. Now, do you have money to hire a lawyer of your own choice?
No.
Well, do you know a local lawyer, one you'd want to represent you?
Yes, Fred Turner.
For the record, I'm going to appoint Mr. Fred Turner to represent this defendant, Clarence Earl Gideon.
Your Honor, because of Mr. Gideon's victory in the Supreme Court, as you know, the state of Florida has now passed a public defender law, and there is no
want a minute.
defender.
We'll let Mr. Turner handle the case himself. Now, Mr. Gideon, you get in touch with Mr. Turner so he can file any motions he desires.
I want to file my own motions. This would be a matter of just sending me back to penitentiary. I want to do it my own way. A motion. A new trial in the case of the petitioner Clarence Earl Gideon is barred as improper because, one, the Fifth Amendment to the Constitution of the United States expressly prohibits putting a man on trial twice for the same offense, and two, the state of Florida has a 2-year statute of limitations on my alleged offense, which alleged crime was committed more than 2 years ago.
I'll rule on the motions at a later date. Mr. Gideon, pending trial, I'll set you free on $1,000 bail if you can raise it.
Can't raise it.
Trial is set for 1 month from today, August 5th, 1963.
Hi, Clarence. How you doing today? Well, I see they got your glasses out to you. That's good. And I think that suit looks real good. We got to talk about it. I got to do this thing, so I'm not going to put you on.
I've heard all about what you've done, and I just wanted to come down and cheer you on.
Sure nice of you. I got a lawyer this time. He's been out working, asking questions, talking to people, finding out the truth.
Thank you.
All rise, please. God save the United States of America, state of Florida, and this honorable court.
Help us to do impartial justice.
Be seated.
Case of the state of Florida versus Clarence Earl Gideon. What says the state? You ready for trial?
Ready, Your Honor.
Defense ready?
Ready, Your Honor.
Ready, Your Honor.
Mr. Gideon, you have made a motion to the effect that this trial represents double jeopardy, and that retrial is also barred by the statute of limitations. A retrial as a result of a prisoner's own appeal is not double jeopardy, and the statute of limitations does not apply where an appeal results in a new trial. Motion denied. You may question the jury, Mr. Harris.
Do any of you have any prejudice for or against a defendant that might prevent you from doing your duty? They're acceptable, Your Honor.
Your Honor, we'd like to challenge Mr. Larwin and Mr. Polk. Larwin doesn't like alcohol, and Polk's the convictor.
This jury is acceptable, Your Honor.
Acceptable, Your Honor.
They call you first witness.
Lester Wade. Lester Wade.
Well, raise your right hand. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God. I do. Proceed.
Mr. Wade, where were you at 5:30 in the morning on June 3rd, 1961?
Outside the Bay Harbor pool room.
Who or what did you see?
Seen Clarence Earl Gideon inside the pool hall.
What else did you see?
Well, I seen him come out with a pint of wine and then leave in a taxi. Then I went back to the pool room and seen it was busted into, cigarette machines busted into, coin box lying empty on the pool table.
Did you notice anything interesting about Mr. Gideon when he came out?
Yes, sir. His pockets was all bulging.
Your witness. Mr. Wade.
What were you doing outside the pool room 5:30 in the morning?
Oh, I just come back from a dance in Apalachicola.
How'd you come back?
In a car with some friends.
Oh. What were their names?
I don't remember now.
You don't remember any of them?
Well, not right now.
Well, can you tell us what kind of car it was?
Yeah, old model Chevrolet.
These, friends of yours, how come they put you off 2 blocks from home when they just driven you 60 miles?
Yeah, I don't know. I mean, I didn't see no
What?
point. Well, I was just gonna hang around there until the pool room opened at 7 o'clock.
Y'all been doing a little drinking that night?
A beer or two.
Where was that?
Apalachicola.
Well, now, Lester, the stores closed at midnight at Apalachicola. When you and your friends got back at 5:30, could you have still been maybe a little bit thirsty? Did you go inside that Bay Harbor pool room?
No, sir.
You didn't come out of there with a 6-pack of beer?
No, sir.
Well, now, you spend a lot of time around the pool hall, do you, Lester?
Some.
Well, now, there's always a lot of advertising boards in the window, aren't there? Now, how could you look in there and see somebody with all those posters?
Well, I did.
And the windows, they're kind of high up. I mean, they're almost too high to see through, aren't they? Now, you did not call the police, then or later.
That's right.
Have you ever been convicted of a felony?
No, sir. Well, not convicted. Well, I stole a car once and was put on probation.
Now, wait a minute here. At the first trial, when Mr. Gideon asked you if you'd ever been convicted of a felony, you said, "No, sir. Never have." That's a false answer, reflecting on Wade's character and his credibility as a witness.
It's not necessarily a false statement.
It is, too.
No, pleading guilty is not the same as being convicted.
Well, it's just exactly the same.
That's enough arguing about it. You both made your point.
Mr. Wade, have you ever denied that you were guilty of a felony?
Yes, sir.
When and where did you deny your criminal record?
Right here. In his last trial.
That's all.
Was Clarence Earl Gideon authorized to be in